The next case to come before us, so is State versus Stultz. And I'm just wondering if you are ready to proceed, or we need to wait for somebody else to be here, or any spectators or anything. Ready to go?
Just me.
Okay, all right. Well, you know the rules, but 15 minutes you'll have. And also don't mention victims or children's names.
Okay.
Thank you.
Go ahead.
Go ahead. I'm sorry, go ahead.
Thank you, Your Honor. May it please the court. My name is Stephen Hanadel. I represent the appellant David Stultz. This is actually a reopened appeal. This court had previously decided the appeal and affirmed, but then allowed a reopening based on the fact that prior counsel failed to make sure that the dash camera video, or not dash camera video, it's more the cruiser video of the back seat of the cruiser that was played during trial, but for whatever reason was not in the record that was forwarded to this court. So, and ultimately, and fairly or unfairly, it is ultimately the burden on appellant's counsel, and it's a burden that I hate too, but it's something I've learned to accept as I've done these often enough. And prior counsel, who was relatively inexperienced at this, he failed to check the record and to see if in fact that the video was in the record, and he admitted to that in an affidavit, and just offered his apologies and really regretted not making sure that the record contained the video, because that was essential, because he argued the fact of the case in the underlying appeal in this court, and he argued that the dash camera video was improperly admitted as evidence played before the jury, and in which this court refused to consider that assignment of error because it couldn't view the video because it wasn't in the record. So now that this appeal has been reopened and the video is in the record, the court can see it for itself, but enveloped in the argument that it was improperly admitted, yes, it was an effective assistance of counsel by prior appellate counsel to not make sure that the video was in the record, because it was an essential linchpin to his argument that the video was improperly admitted as evidence and improperly played before the jury. So, and ultimately, since this court is a review court, it's confined to reviewing the items that are only in the record and does not consider matters outside the record. It's incumbent upon the burden on the appellant to make sure that the record contains all the necessary materials for this court to review. And so, therefore, it was ineffective, on prior counsel's part, and it's just one of those things that will chalk up as a learning experience, as we all have in our careers. But moving on to the improper admission, there was a dispute factually in the trial about who was driving the car. And the state maintained that Mr. Stultz was driving. Mr. Stultz maintained that the person he was with was driving. A 17-year-old he was with was driving. I think somebody might have done some landscaping work for him or something like that. And there was no dispute that Mr. Stultz was intoxicated. Nobody's arguing that. But the cruiser video, when Mr. Stultz was taken, was placed into custody and was in the back seat of the police cruiser and then taken to the police station. The dash camera video showing him being drunk and irate because he's upset that he got arrested, and he just starts making unintelligible statements, a lot of mumbling, a lot of profane remarks, and threatening to sue the police. I mean, just a lot of unintelligible, irrational statements on his behalf. But number one, there was no admission that he was driving. There was no discussion about that at all. And number two, none of what he said was in any way probative as to whether he was driving or not.
But when did that stipulation come that he was intoxicated? Was it after this argument about this particular video in the trial?
Well, he didn't understand that he had about 8 drinks.
That was post this witness, right?
That would be, assuming that the prosecutor played the video and then he testified after that. But yeah, he admitted on the stand that he had 8 drinks when they ate out at Maley's in Westlake, and think it's reasonable to assume that e-drinks is gonna make anyone intoxicated.
So there was no offer before the trial to say, look, the only thing I'm arguing, I wasn't the driver, I'll stipulate to I was intoxicated, I'm only trying this case to the jury and whether I was the driver, so you don't need to show this because there's no question of my intoxication. That did not happen before trial, did it?
I believe defense counsel did raise an objection to the video being played. And so to that end, and I don't fully recollect what the transcript said, but I believe that, to that effect, he was making the point that, look, we don't need to show that he's intoxicated, like, we're not disputing that.
Well, they try to pull the eye, they have to prove he's under the influence in some capacity, so they have some need to prove that evidence unless your client stipulated to.
Correct. So
Your client was not stipulating to that.
well, I don't know if he necessarily has to.
Well, I'm just making sure I understand. And your client did at the start of the trial, said, I'll stipulate to my intoxication, don't show this video, I admit I was drunk.
I do not recall,
Okay.
as far as that being the case, but I do know there was testimony by the officers, just talking about, when they arrived to his house, that he was visibly intoxicated, slurring his speech, the odor of alcohol, the glassy eyes, all those classic hallmarks of somebody being intoxicated. So there was officer testimony by the state, and I don't think any of that was really disputed on cross-examination. But nonetheless, he did object to the playing of that cruiser cam video, especially because there was no need to prove that he was intoxicated, and that's all the cruiser cam video did prove. I mean, it didn't prove anything else.
There was a need, because that's an element of the offense, and if there's no stipulation, the prosecutor does have to prove intoxication. I think that's
But he did prove it. But he also proved it with the officer testimony. He has several officers, not just one officer, but there were more, at least two that testified that as to his mannerisms and behaviors, and that clearly demonstrated he was intoxicated.
So is your position that it's relevant, but it was unfair prejudice because of
Yes.
the cumulative evidence? Is that
Yes, and that's ultimately what I argued in the brief, that the unfair, and so this is ultimately a balancing act by the court in terms of I'm not saying that this wasn't like 100% not probative, but the probative value, if it is outweighed by unfair prejudice, then it should not be admitted. And I think that's what we have here, is that the unfair prejudice is, the standard on that is the quality of evidence that might result in an improper basis for a jury decision. And we're talking about evidence that arouses a jury's emotional sympathies, evokes a sense of horror, or appeals to an instinct to punish, then that evidence may be unfairly prejudicial. And so clearly when he's being very disrespectful to police officers, I mean, most people don't like that. And so, the officers were just doing their jobs that they were supposed to do. And people in the general public don't take kindly to somebody being drunk and being very disrespectful to the officers, and making profane remarks and starting to sue them and so on and so forth. And that something like that is inflammatory. That's not. I don't know of any reasonable jury that's going to take kindly to that, especially when there's no evidence of the police officers not doing their job properly. So to that end, it was just piling on. It was cumulative, and that video was unfairly prejudicial because all it's meant to do is not just showing he's intoxicated, something they already established through officer testimony, but just showing just his drunken behavior toward the police officers, and that's just all to get the jury to not like him. And that's all that video does, is just to make the jury not like him. And therefore, when it comes to he's presenting his side of the story, saying, hey, no, I wasn't driving. When it comes to who is the jury going to believe in the conflicting testimony, then that video does make a difference because the jury is thinking, gosh, yeah, he was a jerk, and then tend not to believe him. So I think that this matter should go back to new trial, that video not shown, and then let's just see what happens, because there will still be the officer testimony that he was intoxicated and so on and so forth. I mean, they're still going to testify as to how he acted and behaved when they arrived to his house. And they testified as to how he acted, you know, when he was, you know, at the police station, the fact that they had to help him stand up. He was struggling to stand on his own, and he needed assistance, slurring his speech, and so on and so forth. All that would still come in, and I lost my train of thought for a second. So all that would come in, but you know, but as far as that visual of him just making profane remarks to the police, I mean that just has it's unfairly prejudicial, because all that's doing is it's just making the jury dislike him and therefore not believe his side of the story when he presented a defense. So I think, yeah, and even in a new trial too, I mean, his statements on the witness stand are probably going to be admissible, you know, even if he doesn't testify in a new trial, but his statement, the fact, you know, his statements on the stand are likely admissible to party admission. So there's not going to be any dispute as to his intoxication. It's just that, you know, when the jury's presented with somebody who was very disrespectful to the police officers who were just doing their jobs, you know, and when you're dealing with a conflict in the facts and in the testimony, that's going to have an unfair prejudicial effect as to who they're going to believe. And so as far as, you know, even though I don't recall specifically whether there was a stipulation or not, but I do know, to the best of my recollection, that the defense counsel, I think, made it clear that he was not disputing the fact that Mr. Stultz was intoxicated. And that was, and I know there was some discussion about that prior to the judge deciding to admit the video anyway and overruling the objection. So, so again, I think, you know,
I can't remember, was the video objected to just upon its admission or before it actually was played to the jury?
it was close. I know it was around the same time frame.
Was it actually played was it actually played at court at the time?
It was, the transcript bears shows that it was actually played. I do believe that there was a snippet in the transcript that video being played, so that it was played before the jury, it was admitted as evidence, and for whatever reason, it wasn't admitted as an exhibit, and it just was not included as part of the record forwarded to this court the last time. It is this time, I made sure of it, and so it should be in there, and I believe I double checked. So, but like I said, it should not have been played, and you know, the state did not. This was just cumulative evidence that the state had already proven its point that there was intoxication. The defense was not disputing that, and other than intoxication, that video has no other probative evidence, and it just results in unfair prejudice because of the fact he was being so
As far as
disrespectful.
harm was there, I presume ultimately the defense is that he wasn't the driver. When the police came up to the vehicle, was he in the driver's or passenger seat?
He was in the driver's seat. So the testimony was that that the 17-year-old he was with backed into the driveway. They each got out of the car. Well, in fact, he was dropped off first. He said he went inside the house to put his leftovers in the fridge because they were at a restaurant. Put his leftovers in the fridge, and then the 17-year-old that also went in the house to the backyard to tend to his dog, and that Mr. Stultz came out to check on the van because it's a service van that he uses for his business. So he was just going to, until he got into the driver's side to check on to make sure the van is ready, you know, for service the next day. And granted, you know, he might not have been in the best state to effectively do that, but I mean, intoxicated people don't always make the best decisions. You know, they think they might be fine or whatever, but they don't always make the best decisions. But and that's when the police pulled in, when he's sitting in the driver's seat, the door's open, it's in park. He maintained that the engine was not running, and so that's where the police found him, and that's when they started talking to him, and that's when they noticed that he was clearly intoxicated. So there is no like direct evidence that he was driving. I mean, everything is circumstantial and based on inference And, you know, the testimony of the witnesses behind the vehicle, watching the vehicle, you know, swerve a little bit, they didn't know who was driving either. They were not able to tell who was driving. So there's no person or video or anything that says, aha, that's clearly him behind the wheel. And so, given that there is that dispute, the state had to prove the notion that he was driving. They had to prove that through circumstantial evidence. And given that he maintained he wasn't driving, that's where that video really mattered a lot.
And you're at your limits per time. So,
Okay.
So,
All right.
all right.
Well, and I'd ask the court to reverse and remand for any trial.
All right.
Thank you.
Thank you very much. As you know, we'll take the matter under advisement, issue a written opinion. That will be sent to both sides, and we release on the Supreme Court website.